everybody. I think this is gonna be my last video for the day. Hopefully. But yeah, okay. So I just had another video come out. I mean, y'all might have been sitting in the premiere right now while I was going live for this, but I'm so tired and I just want to get it over with. So make sure you go and check out that video I just made. Okay, but Diddy has filed, or his lawyers have filed, as required, as expected, a memo, a memorandum of law in his criminal case. Now, what is the memo for? It is in support of Diddy's motion for a hearing, for suppression, and for other relief. This all has to do with that prison, jail, BOP sweep. Okay. So I just want to go over that quickly with y'all. He says, and I believe this is, let's see, who wrote this? Was it Agnifilo or was it Alexandra Shapiro? Yes, she has really taken the front seat on this part of the trial, on this part of the pretrial stuff. And it really, I noticed that it was, in my opinion, from what I noticed, it was after Mark Agnifilo got busted saying that something said legal notes on it that didn't say legal on it at the time. And this is still dealing with that. Alexandra and Mark and, Diddy's lawyers say it is indisputable that a BOP, a Bureau of Prisons investigator based in West Virginia, has been feeding Mr. Combs jail communications to the prosecutors. Okay, based in West Virginia. That is probably like Quantico, or wait, Quantico's in Virginia or West Virginia? Somewhere about DC, I'm assuming, if this Bureau of Prisons investigators based in West Virginia, but I don't know. I don't know anything more than y'all know just looking at this. So Diddy's lawyers say it is indisputable that this investigator based in West Virginia has been feeding Diddy's jail communications to the prosecutors, to the feds. Diddy's lawyers say it is also indisputable that this investigator traveled to New York for a Bureau of Prisons sweep, ostensibly aimed at, quote, potential corruption and contraband at the Metropolitan Detention Center. The lawyers say despite finding none, this investigator inspected and copied Diddy's privileged notes. At the very least, this egregious invasion of Diddy's constitutional rights raises numerous questions that can only be answered through discovery and an evidentiary hearing. So, Alexandra Shapiro, this is Diddy's lawyer, we're in Diddy's criminal case. She's saying at the extreme least, at the very least, this behavior of this Bureau of Prisons investigator, it is egregious, and it is an invasion of Diddy's constitutional rights. At the very least, it raises numerous questions that can only be answered through discovery and an evidentiary hearing. So he wants a hearing. The government's breezy response stoops to unjustified and irrelevant mudslinging and mischaracterizes the controlling case law and key facts about the filter team protocol. Apparently lacking any concern for the fairness of these proceedings, the feds minimize the breaches of Diddy's privilege and privacy, hoping that this court will accept the government's, that's the feds, unsworn say-so and not bother with a hearing. The defense has repeatedly, that's Agnifilo and Alexandra Shapiro, they're saying we have repeatedly presented sworn testimony signed under penalty of perjury and stuff like that as evidence. But the government offers no actual evidence, Alexandra Shapiro is saying, supporting its slippery and inconsistent claims about the underlying facts sufficient to meet the controlling legal standard. Instead of submitting, for example, a sworn declaration by this investigator explaining in his or her words what happened and why, the feds expect the court to simply accept their unsworn hearsay assertions, even though they are self-contradictory and provide few answers to the legal questions. The court should refuse to do so. The court should insist on sworn testimony from investigator one and the production of his written communications with the prosecutors. Diddy's lawyer says a hearing is the only way to find the true facts so the court can assess how best to remedy this grave violation. The argument is that the government doesn't explain why this investigator searched Diddy's notes, which underscores the Fourth Amendment violation. The government misreads the Second Circuit precedent when it claims that the Fourth Amendment doesn't apply to prison searches. That isn't what they said either. They didn't say it doesn't apply. Like, they said that it is. I don't know. I don't exactly remember, to be honest, but I'm pretty sure I remember them saying it is diminished a little bit, or it doesn't apply to exactly the same standards when you're in custody. The Second Circuit has squarely held that the Fourth Amendment scrutiny is required for prison searches. Warrantless searches performed at the instigation of non-prison officials for non-institutional security-related reasons, or warrantless searches which are, quote, intended solely to bolster the prosecution's case against a pre-trial detainee awaiting his day in court, or warrantless searches that are for, quote, to uncover information that would aid them in laying additional indictments against a detainee. These are out of bounds and they may be challenged. Well, if this is true, then that actually helps Diddy a lot, because these are the two arguments that they are relying on. One is that this search was intended just to bolster the prosecution's case, the search of Diddy's notes and things like that. Or to uncover information that would aid them in laying additional indictments against a detainee. These are out of bounds and they may be challenged. Additionally, Alexandra Shapiro, they're also claiming over there that this was only to uncover more information, to get more information for the grand jury to add to the indictments. So if this is true, then that doesn't look too good. However, the government is saying these are not the reasons for this search. The feds have always maintained that this was a pre-planned search. They didn't do it for the purposes of searching Diddy. But then Diddy's lawyers are saying even if they didn't, they went into his stuff, into his locker, into his notes, took pictures of it, put it back, didn't tell him. So there's more considerations than just that. Alexandra Shapiro says the issue is not whether the sweep in general was motivated by a larger safety and security initiative. Yeah, this is what I just said. The issue is why investigator one searched and photographed Diddy's personal notes and immediately offered to share them with the feds. That's the issue they're claiming. Diddy's lawyers are claiming the issue is why did this investigator search and take pictures of Diddy's stuff just to immediately share them with the prosecutors? The feds still have not offered any explanation whatsoever for these actions as to the notes, even though the court specifically did ask the prosecutors at the November 19th hearing whether investigator one thought of himself as an agent of the prosecution team and, quote, took it upon himself to aid the investigation effort by photographing the pages. The government refuses to tell the court what investigator one has to say about his motivations or thinking. But that is the dispositive question. So we need to know, Diddy's lawyers are saying, we need to know, what does investigator one have to say under penalty of perjury about his actions? Because all of this hearsay isn't going to cut it, Alexandra Shapiro is saying. Rather than even attempting to provide any explanation from investigator one, sworn or unsworn or otherwise, the feds instead offer up a series of red herrings about things that, quote, may justify prison searches, but have nothing to do with the search of Diddy's notes or even the Bureau of Prison Sweep more generally. The government claims, for example, that a prisoner's notes may contain details of an escape plan or be used to hide contraband images. Diddy's lawyer said, so what? So what? That was plainly not what motivated the search. or why Investigator 1 searched Diddy's notes. The far more likely reason, Alexandra Shapiro says, for Investigator 1's conduct is the same one that motivated his prior work on the case. Quote, he sought to collect evidence for this prosecution. So Diddy's lawyers are saying, that's all cute, fine and good, but it's not true. We know just as good as everybody that the more likely reason that this man came in here and took pictures of Diddy's stuff and all of that was to get evidence for this very case. The government admits that Investigator 1 had been reviewing Diddy's recorded phone calls and emails since Diddy was detained. Throughout that period, quote, the case team had communicated with him, I think it's the investigator, regarding Diddy's monitored communications and had issued legal process to obtain the communications. The government does not detail those communications, but it never denies the obvious. And they're saying the obvious in this case, quote, Investigator 1 understood himself to be investigating Diddy's communications on behalf of the prosecution team. The government denies coordination before the search, but even if that was true, the claim ignores the context. Okay, and then what are they saying the context is? That the case team, that's the feds, prior work with this investigator to procure evidence against Diddy. Okay, so they're saying that's all fine and good. Maybe they didn't coordinate together before the search, but they were certainly coordinated and they certainly were acting together in other ways. So Diddy's lawyers are saying, that's just semantics. The government makes contradictory assertions that cannot be resolved without a hearing. So they're saying they need a hearing. On the one hand, the government claims the search was initiated by a prison official for a legitimate penological purpose. But then on the other hand, the feds are admitting that they obtained the BOP notes in connection with a covert investigation into Diddy's ongoing obstruction and witness tampering. The government even says Investigator 1's purpose might have been preventing crimes, such as efforts to obstruct proceedings. In other words, to further its ongoing investigation. So Diddy's lawyers are saying, look, they kind of admitted that this was to further their investigation because they were, quote, working on preventing crimes such as efforts to obstruct these proceedings. Diddy's lawyer says, which is it? If, as the government concedes, this investigator's aim was to uncover info to support additional charges and Diddy's continued detention, that is not a legitimate institutional security purpose, and it would violate Diddy's Fourth Amendment rights. The government's bald assertion that there was a legitimate penological purpose contradicts its own admissions about Investigator 1's role. So they're saying the government's contradicting itself with all the different reasons it has given. Notably, contradicts its own admissions about Investigator 1's role in assisting the prosecutors to develop evidence against Mr. Combs for this case. And notably, this contention is unsupported by any affirmation or declaration. So they keep bringing it up. Diddy's lawyers keep repeating it over and over. There's no sworn testimony, Your Honor. We're over here signing stuff under penalty of perjury. We're giving you affirmations. We're giving you declarations. We're giving you affidavits. But we don't have any of those things from them. Where's their prosecutor affidavit, Investigator 1 affidavit, or a prison official? Diddy's lawyer says the court should not blindly accept this self-serving assertion from the government. The only way to ascertain the truth is at a hearing. The government's cases don't even help their case. The Williams versus Ramos case dismissed a claim alleging prison officials confiscated the detainees' legal papers without any involvement of prosecutors. So that one is different because then she distinguishes this case from all of the cases that the government cited. They're saying, no, these don't actually help them. And this has nothing to do with prosecutors. In this other case, Ortiz versus New York, this was something about the prosthesis and medical equipment, like a prosthetic and medical equipment. Again, this had no involvement of prosecutors. They cite another case about the chosen freeholders of County of Burlington. This considered a challenge to a jail's general strip search policy upon their entry into the facility. But this doesn't address the standard for challenging particular search of a pretrial detainee's papers. So that one doesn't count. That one can't help them. They also cite this Stroud case, which predates this other case they had relied on named Cohen by decades. In that case, the Stroud case, papers were seized pursuant to established practice at the penitentiary. And they're saying that in Diddy's case, this was not an established practice. Finally, the United States versus Ciancia considered a challenge to the search of an inmate's mail, which federal law permits. Okay, so they're saying, look, all these cases, Your Honor, that they tried to rely on over there, the feds, none of them hold water, and these are the reasons why. In Cohen, the Second Circuit directed courts not to merely pay lip service to a pretrial detainee's Fourth Amendment rights. Yet that is exactly what the government is asking the court to do here. Take the government's word for it and just ignore all the facts and the logic showing the opposite. The court should resist that invitation to disregard Diddy's rights and paper over the violation. Then the lawyers argue that the government actually violated Diddy's Sixth Amendment rights. The government's only response to Diddy's Sixth Amendment argument is to breezily assert that its conduct was reasonable and caused no prejudice. But the court cannot simply accept the government's claim, especially because it's unsupported by any evidence, and it's implausible on its face. Again, they're renewing without finding the actual facts through sworn testimony and proof adduced at a hearing. So again, renewing again, we need a hearing. The government says the intrusion was not intentional, but offers no sworn declaration that would enable the court to understand the underlying facts or justify the breach. If investigator one inspected the notes and photographed them to assist the prosecutors, as demonstrated above, then that intrusion at issue was intentional government conduct that requires careful scrutiny in the form of a hearing. So they just keep going over and over. We need a hearing. We need a hearing. This is the reason. This is another reason. This is another reason. The government ignores Diddy's case law, criticizing similar government conduct and ordering a hearing. Instead, it cites non-binding, unpublished decisions on whether, in the unrelated Brady context, the Bureau of Prisons was an arm of the prosecution. These cases do not apply. They are inapposite. Since investigator one is obviously a state actor, his actions are attributed to the government for Sixth Amendment purposes. The feds, further contend incorrectly, Diddy's lawyers are arguing, that the feds never deviated from established filter team protocol. I guess they stopped saying taint team now. Never deviated from established filter team protocol, the feds allege they never did. The feds allege they never did. And that Mark Agnifilo and Alexandra Shapiro have a misunderstanding about the protocol. Diddy's lawyers said that is simply untrue. After Diddy was arrested, a filter team prosecutor explained to Diddy's lawyers that the filter team would share a privilege log with the case team, but would afford defense counsel, that's Diddy's lawyers, the opportunity to review identified materials and assert privilege before any potentially privileged documents were shared with the case team. Okay, so Diddy's lawyers are saying the government told you, Your Honor, that they followed all of the protocol of the filter team, but that's not true, because they told us that their protocol was to tell us before they shared anything with prosecutors to make sure that we approved and we were going to be able to raise the issue of privilege before it was just shared over there, and that wasn't followed. Diddy's lawyers say, indeed, the government confirmed this understanding in its prior representations to this court, which squarely conflict with the new position articulated in its opposition brief, when it said our filter team reviews the full device and removes, before the case team can see it, any potentially privileged information. That set of potentially privileged information will go to the defense, and they are able to make privileged calls. That is clearly evidence that the government intentionally diverged from protocol. Okay, so they're saying the government, the feds, they said what their protocol was and they didn't follow it. And now they're trying to tell you they did, but they clearly didn't. And here's some citations to their own admissions as such. And then they're saying this is all the more reason why we need a special master. We need a special referee to come in unbiased who's not working for these people and with these people because they don't know how to act. The government's bare assertion that the case team prosecutors access the privileged materials inadvertently and not intentionally, this is implausible, particularly considering the government's prior representations to the court about filter protocol. The court should test that claim again at a hearing. Again, they want a hearing. Diddy wants a hearing on the issue of this search. Even the redacted portions of the notes still contained facially privileged materials that any lawyer undoubtedly would have recognized as privileged. Again, this is up for debate because did it say legal up on the top or not? Stuff like that. That is particularly true given the case team's awareness of where the notes came from. Okay, so he's saying they're stupid. Alexandra Shapiro is basically saying, Your Honor, please don't let them fool you. They knew that crap was privilege. Look, listen, I'm not saying I agree with her. I'm just doing, I like to do it from each person's side so it's easier to understand. And she's saying, don't let them fool you, Your Honor. Even the redacted portions of the notes still contain facially privileged materials that any lawyer would undoubtedly have recognized as privileged. This is particularly true considering that the feds, the case team, they knew where the notes came from. They came from inside Diddy's prison locker, jail locker. Their initial concern that they might be privileged. If the prosecutors had any doubts or hesitations as to the meaning of the notes, the proper course of action was supposed to be to communicate with Diddy's lawyers or seek relief from the court. It was not, the proper course of action was not to file the notes on the public docket while seeking Diddy's continued detention. And I actually agree on this one point with them. I don't feel like there was really any need for the government to add on and to pile on this evidence at that stage. And I feel like that did allow an opening for Mark Agnifilo and Alexandra Shapiro and them to make these claims. They say at best the case team was willfully blind to the fact that the notes contained privileged materials and deliberately chose to stick its head in the sand and use them without first confirming that they were not actually privileged. As for prejudice, the defense, that's Diddy and Mark Agnifilo and them, the defense should be permitted to review and respond to the ex parte letter, detailing what the government learned and how it has used the privileged materials. As explained below, the normal process endorsed by the Second Circuit is a Kastigar hearing. Okay, so the normal process and has been endorsed by the Second Circuit is a hearing under this standard of the Kastigar court. There's no way the court can fairly and accurately evaluate the fruits question without input from the defense. Indeed, ruling on this issue without allowing Diddy an opportunity to respond to the government's letter would violate due process. But I'm not sure that responding to the letter necessarily requires a hearing. Like he could respond to the letter in a filing because the allegations were made in a filing. I don't see why he necessarily needs a hearing to remedy this, or she, or whatever, but they're saying that they're pretty much pushing their weight around. They're saying if the court doesn't let them have a hearing, then that in and of itself will violate Diddy's constitutional rights. There is no way the court can fairly and accurately evaluate the fruits question, the fruit of the poisonous tree, I think is what they mean, without input from the defense. But input from the defense, does that mean a hearing? I don't think so. Alexandra says, indeed, ruling on this issue without letting the defense respond to the government's letter would violate Diddy's due process rights, which, quote, demands the opportunity to correct or contradict arguments or evidence offered by the government. And regardless, the government has clearly seen aspects of Diddy's trial strategy that it should not be privy to. Now, what was exactly in all these notes? I don't know. I have no idea because it wasn't all made public to us. It was only a very few like sentences that were made public to the public. The notes on their face are not just vague allusions to usual defense tactics. They reference how to discredit particular allegations and witness testimony, obtaining specific types of experts for trial, and collecting cross examination material on particular witnesses. Moreover, the feds failed to explain why Investigator 1 rifled through 7 pages of additional privileged material to photograph pages 1 and 2 of Exhibit 1, or what Investigator 1 told prosecutors about those notes. Finally, the government admitted that it listened to Diddy's calls with family members and his attorneys and reviewed his messages with dozens of individuals, including attorneys. Yet it neither offers any explanation for this surveillance nor promises to refrain from such spying in the future. This further highlights, let me guess, the need for a hearing? Let's see. This further highlights that the prosecutor's invasion of the defense camp and violative use of the privileged information is likely just the tip of the iceberg. A hearing is required and the issue is not moot. The government, excuse me, the government seeks to avoid adjudication. So the feds seek to avoid going to trial or going to a little hearing on this issue by offering to avoid using any fruits of their notes that they got from the Bureau of Prisons sweep. The feds claim that this gesture renders most of the disputes moot. But the suppression of the fruits is not merely a matter of grace in the government's discretion. It is required by law, nor is the need for the hearing moot. So the government says that, oh, we'll just be nice and not use it. We'll show grace. We won't use it. And so therefore the hearing isn't necessary. Diddy's lawyers are saying, nope, wrong. Back it up. Both of those contentions are incorrect. There's no question that a Fourth Amendment violation, if proven, requires suppression of all fruits. Fruits is like fruit of the poisonous tree. It's like whenever a constitutional right is violated, like an unlawful search and seizure or a Sixth Amendment violation or something like that, specifically like for sure this unlawful search and seizure, the Fourth and Fifth Amendment, then anything that was gotten in that search, like let's say it was a search of a house or whatever without a warrant, anything you found in that house in that search, you can't use it ever. It's considered to be the fruit of the poisonous tree. So Diddy's lawyers are saying, okay, but if we can prove there was a Fourth Amendment violation, that evidence must be suppressed under the law constitutionally. This is also true for violations of the Sixth Amendment. So we're talking about Fourth and Sixth. This is the unlawful search, and the Sixth is the right to represent, meaningfully participate in your defense, the right to an attorney, right to speak to an attorney, stuff like that. Relying entirely on out-of-circuit cases, the feds claim the remedy for a Sixth Amendment violation is suppression of the privileged material only, but not the derivative fruits. But the Second Circuit has already squarely held opposite of that, so the feds are not correct in that, is what Diddy's lawyers are saying. The government must demonstrate that the evidence it uses to prosecute an individual was derived from legitimate, independent sources. The government's out-of-circuit cases do not support its argument. Again, they're going to go and tell the judge all the reasons why the cases the government is relying on just don't actually apply. For example, United States versus Marashi, they approved admitting certain testimony over a marital privilege challenge. It dealt with purely evidentiary privilege. It had nothing to do with the Sixth Amendment issues. Okay, so this is marital privilege, and this is about evidentiary privilege, nothing about the right to an attorney, the Sixth Amendment, and stuff like that. So Diddy's lawyers are saying, so that case doesn't square up with the Sixth Amendment issue that we take. In a footnote, the Ninth Circuit said, Even if it had found a marital privilege violation, it would not have required exclusion of all fruits. Subsequently, however, the Ninth Circuit squarely held that a Sixth Amendment violation does require use and fruits suppression. So we're talking about Sixth Amendment, Diddy's lawyers are saying. So this marital privilege thing over here has nothing to do with the Sixth Amendment. We ain't talking about that. The Ninth Circuit applied Kastigar just as the Second Circuit did. So the Ninth, okay. So they're saying they're going all out of circuit, talking about Ninth Circuit, talking about Second Circuit. But even if we do rely on these cases, they don't really have nothing to do with this. This is not a matter of them just being nice. They are required to not use anything they found as a result of this search. That's what Diddy's lawyers are claiming. Nor is there any legal authority permitting the government to satisfy its obligations under Kastigar by simply filing a little letter explaining what investigatory steps it has taken after it obtained privileged materials illegally. To the contrary, under the case law, the government must present evidence and must show, the feds have to show by a preponderance of the evidence that all of the evidence the feds are going to use were derived from legitimate independent sources, namely, i.e., not from the prison search. The Kastigar standard requires an evidentiary showing. There needs to be evidence. And again, Diddy's lawyers are saying there is this, the government said, say so, they heard it through the grapevine, what the prison usually does and stuff. That's not evidence. We need sworn testimony from the investigators or from the prison bureau or from somebody over there, the warden, something. This is standard practice. We need the evidence. The Second Circuit has held that the prosecution cannot satisfy its burden of proof by offering bare, self-serving denials. They can't just come out and say, no, we didn't do that, Your Honor. No, they need evidence. This has been the law of the circuit for decades. The heavy burden cast upon the government to prove independent sources is not satisfied by the prosecution's raw assertion that tainted evidence was not used. The defendant is entitled to a fair hearing at which the government must make an affirmative showing with evidence. And then they're going to argue, in addition to this hearing they want, Diddy also wants appointed a special master. This would be somebody whose job it is to referee the issue of privilege. Because right now, Diddy is saying the filter team, the tank team, they ain't cutting it. They ain't doing their job. Neither the Second Circuit nor any other circuit has ever restricted the use of special masters to exceptional circumstances, as the government tries to argue. To the contrary, special masters are used regularly in jurisdictions around the country, and for good reason. The government criticizes the defense for failing to cite any Second Circuit law disavowing filter teams, but the government itself fails to cite any Second Circuit law approving filter teams. Ooh, that's a good one. The government gets mad at us, Your Honor, because we didn't cite any Second Circuit law disavowing filter teams. They said, okay, well, back at you, government, because y'all didn't cite anything approving them either. Much less holding that they should be standard practice or that special masters are reserved for exceptional circumstances. Nor have courts in this district uniformly or routinely approved the practice. Actually, to the contrary, the implementation of a Chinese wall, especially in the context of criminal prosecution, is highly questionable. I don't know what this Chinese wall is about. I don't know what that's about. If filter teams are standard practice in this district, that is only because the U.S. Attorney's Office here has made a self-interested decision to make it a standard practice. Ooh, that's a good one. Ugh. I know y'all hate it when they make good points, but that's a good one. If filter teams are standard practice, it's because they made it a standard practice by putting their own little silly little filter teams on it. Filter teams are not a standard practice nationwide either, as the government contends. Even within the Department of Justice, no official policy prefers the use of filter teams. To the contrary, the U.S. Attorney's Manual expresses no preference between filter teams and special masters, and many courts around the country have rejected the idea that government-run filter teams should be, what is this? De rigueur? I don't know what that means. Should be the run-of-the-mill. Quote, although use of taint teams has been approved in limited factual scenarios, federal courts have generally taken a skeptical view of the government's use of taint teams as an appropriate method for determining whether seized or subpoenaed records are protected by attorney-client privilege. That is because filter teams present inevitable and reasonably foreseeable risks to privilege. For precisely these reasons, some jurisdictions require the use of special masters in circumstances where government searches are likely to obtain potential privileged material. So I kind of don't disagree with them here. I really don't see what the issue would be with having a neutral special master whose job it is to be focused on this. If I am a criminal defendant and I'm being tried by the U.S. Attorney's Office, I promise you, I don't want people working for that U.S. attorney to determine what my rights are. That does feel off. That feels odd. And so if it's normal and doable to get a disinterested third party who doesn't work for any of the parties in the case, doesn't work for the U.S. attorney, but also doesn't work for Diddy either, I think that's fair to me. I don't see why the judge would deny this. I know. I have another video out. I didn't drop it new while y'all were watching it though. I dropped it before. Anyway, yeah, after this, y'all make sure to go check out. I did another video earlier. I think this is my fourth or fifth video today, but I did update. There's a new filing in the Jay-Z case, in the Jane Doe versus Diddy Jay-Z. Alex Spiro had got fussed at by the judge, but all these little letter motions, and then here he is filing more letters today. So I did do a video on that. It's like 10, 12 minutes long. We're almost done with this one though. Okay, so for precisely these reasons, some jurisdictions require the use of the special masters instead of the filter teams in circumstances where government searches are likely to obtain potentially privileged material. Much of the government's argument boils down to an unsupported policy argument that special masters should be disfavored because they slow down proceedings considerably. But there is no evidence that the regular use of special masters in the Sixth Circuit or California state courts, for example, causes delays. Nor is there any reason to believe a special master would be slower than a filter team if the latter was actually doing its job carefully. Oh, they had to get that one in there. Dang. Ouch. No statute, rule, or binding case holds that a filter team is preferred or that special masters require exceptional circumstances. If anything, special masters should be the standard procedure for obvious reasons, that the government's attorneys cannot be trusted to protect the defendant's privileges. Regardless, this court clearly has discretion to order a special master, and it should do so here because the filter team has already utterly failed to protect Sean P. Diddy Puff Daddy Combs' defendant's privilege. Dismissal and disqualification remain appropriate potential remedies. Mr. Combs, that's Diddy, reserves the right to seek to have this whole entire case dismissed and or to have the prosecutors on this case disqualified, which may be warranted upon development of the full factual record at a hearing. So again, they are renewing their allegation that what they find out at this hearing is going to come down to whether or not they're going to actually try to have this whole case dismissed. The whole case dismissed. She's saying we need a hearing so we can determine that. For the foregoing reasons, the court should order discovery and a hearing and other remedies as set forth in the opening memorandum. Whew, all right. Well, oh my God, y'all are funny. Stop. Okay, well, I am tired and have been working for about 14 hours. So that's all I really have for today. In the meantime, facts ain't defamation. Love you, mean it. Okay, bye.